Today we're going to talk about the different types of court hearings that are in foster care. I'm getting ready to do a 4-part series. This is part 1, the different types of court hearings. Part 2 is going to be what the foster parent's role is in each of the court hearings. Part 3 is advice for foster parents when they go to court. By popular demand, Part 4 is going to be all the acronyms and what they mean, or not all of them, but a large majority of the acronyms that are used in court and what they mean, so that when you see documents and you see all these acronyms, you know what they are. So without further ado, let's get started and talk about the different types of court hearings. So in the foster care system, there are obviously many different types of court hearings. And so we're going to start in chronological order and talk about what happens and when it happens and so on. So the very first thing that happens is if a child is removed, the county, the school, the police, somebody gets a report, they see something, they do an investigation, they feel like there is a good reason to remove the children from the guardian or whoever the guardian is. Could be a bio parent, could be a grandparent, whoever the guardian is. And if they find cause and that they believe that the children are in danger or neglected in some way, shape, or form, they will remove the children. And so once that happens, the first hearing that happens is called a probable cause hearing. And this hearing has to happen within 72 hours from when the children are removed from the guardian. The caseworker will contact the guardian and let them know that this hearing is going to happen, when the hearing is happening. And so this hearing is very quick. Typically 15 minutes is all that it takes to finish this hearing. There's a whole bunch of things that are a little different in this hearing, and so we need to talk through them. So the first is, they are not trying to prove anything at this hearing. All they need, well, let me rephrase that. All they have to be able to prove is show that there's reasonable suspicion at this point, that there's a reasonable amount of suspicion that neglect or abuse or some form of that has happened, to then move this to the next level. And so the bio parents or guardian are there and they can speak, but they really can't testify because this isn't a hearing. It's sort of more like a grand jury. If you're familiar with how the grand jury works, it's more about, is there enough evidence to take this to trial? Is there enough? And again, the legal termination is there reasonable suspicion, and that's all they need. So if it is determined, yes, there's reasonable suspicion that why the children were removed, then this hearing is over and it now moves to the next hearing. And the next hearing is called a merit hearing. And so a merit hearing must happen within 35 days of the probable cause hearing. And again, let me just state this real quick. This is the way it's supposed to work, as you will find out. A lot of times it does work this way, but I'm telling you, it's court, and so all sorts of crazy things happen. But I'm just telling you the order in which it's supposed to work. So a couple of things about the merit hearing is that the foster parents and the bio parents will be contacted by the county caseworker to let them know when this hearing is going to happen. And so generally in this hearing are anybody that's needed to prove whatever the allegations were. Obviously the defense attorney for the guardian ad litem, or the attorney for the child is going to be present. And so this hearing typically takes 3, 4, sometimes 5 hearings to come up with an outcome. And so generally these hearings are 15 to 20 minutes long. A lot of times at the first hearing, all the investigations haven't been done by both parties, so the defense hasn't fully done all their interviews and all the things they need to do, and DSS, or the Department of Children's Services or Department of Social Services, hasn't done all of their investigations. And so these hearings go on and on and on and on and on, and so the goal of this hearing is to prove, or to say, yes, the children were removed because of neglect or abuse, and there's enough evidence to prove that, and then the judge will approve it, and then they officially go into the system, and that's when a case plan, and we'll talk about that. But if the judge then at some point in time says, no, there was not enough evidence that neglect or abuse happened, then the children are, as soon as the judge makes that ruling, the children are immediately removed from whoever they're with and given back to the guardian that same day. But again, this merit hearing, it generally takes multiple hearings for this to happen. Now, in some cases, a case plan isn't written until the merit hearing has a judgment, but in a lot of cases, they create a case plan because they understand that the merit hearing is going to take a long period of time, and they want services to be able to be offered at that point. Which moves us to the third hearing, and that is the permanent planning hearing. So this is the hearing where the case plan is created, services are offered. This is also this hearing. It happens generally every 60 to 90 days to check on progress. So everybody can be in this hearing. So lots and lots of people. So obviously you'll have the judge or the magistrate, you'll have the GAL, you'll have the defense attorney, you'll have the social workers, you'll have in some cases a CASA, foster parent, doctors, therapists, anybody involved with this case that can give insight to what's going on, what services may need. Teachers sometimes are brought into these hearings, all sorts of things. And so this hearing is where the case plan is made, and then updates to the case plan are done. And so that typically happens every 60 to 90 days and so on. So it's not uncommon for changes to be made to a case plan from hearing to hearing to hearing. This is also where the judge is going to look at the guardian. Is the guardian doing whatever they need to do, he or she needs to do to get their children back? So if they were supposed to take a drug treatment program, let's just say, there'll be updates on that drug treatment program, and the kids might be ordered to be put in therapy, or might be ordered to have some other kind of services for them. And so again, these hearings are going to be updates on that. And so the initial one is build the case plan and figure out what services everybody needs. This includes guardian and foster child. So everybody gets the services that they need. The judge or the magistrate orders those services, and so those services can be done. Foster parents can have a lot of input in obviously in this case, and so in the next video we're gonna talk about what your role is in this case. And then the fourth and final type of hearing that is in the foster care system is called a termination of parental rights hearing. And so generally speaking, this hearing doesn't happen until the child has been in care for at least 1 year. Again, there are rules that will break this, but generally 1 year, and in a lot of cases, it's coming closer to 2 years. So this is the hearing where the guardian ad litem brings to the judge or the magistrate to say, we would like to remove the parental rights permanently and put this child up so that this child can be adopted by someone else. And so again, just like the previous hearing, this generally does not get settled in one hearing. These are long drawn out hearings, as you can imagine. And again, the hearings are generally 60 to 90 days apart from each other. And so everybody and their brother is at this one. I mean, grandparents, uncles, aunts, again, doctors, therapists, you name it. Anybody that has anything to do with this child is invited at these hearings. And so then, even after the judge rules, so let's say the magistrate or the judge rules for termination of parental rights, there are 2, sometimes 3 appeal processes that can happen after that. And so this can take a really, really long time. And sometimes this can drag on 2, 3, 4 years to get this done because of that. The only way this generally goes relatively quickly, which it does, is when the guardian surrenders their parental rights. And so it's a single hearing. They sign a document that says that they surrender their rights. The judge approves it. And I'm going to tell you, the judge is going to ask the guardian a lot of questions before they allow them to do this, because this is a big deal. This is splitting a family forever. And so this is not taken lightly in any way, shape, or form. And these are the hearings where nobody comes out happy most of the time. Generally, these hearings are heated, and the defense is heated, and the GAL is heated, and so they're battling, and this is a true court battle. And again, because there's a lot at stake. So I hope this helped you understand the different types of court hearings. Again, we start with a probable cause. All we got to do is make sure that there's reasonable suspicion. Then we go to a merit hearing, and again, this is proving that the reasonable suspicion was true, and so again, that may take a little while. And then a permanent planning hearing. This is the one that most foster parents attend. This is where case plans are made and reviewed and changed and so on and so forth. Now, I did want to go backwards and say that sometimes the permanent planning hearing will happen at the same time or shortly after the first merit hearing, but not always. But sometimes we'll still have merit hearings going on and permanent planning hearings going on simultaneously, because they want to keep this rolling. They want to make sure services are offered and so on and so forth. And then the final is termination of parental rights. And again, this is only if reunification is not possible in any way, shape, or form. And so they don't go there until they feel like they've exhausted everything they can in the case plan. Again, I hope you have found this interesting. The next video is going to be all about what is your role as a foster parent in each one of these hearings. What value do you bring to those hearings, and so on. So if you like this one, give it a big thumbs up, and I look forward to seeing you on the next video.